Let's bring in law and crime host and legal analyst right now, Terry Austin, for more on this. Terry, good morning. Thanks for being with us.
Good morning, Phil. Thanks for having me.
All right, let's start with this because we often don't see defendants taking the stand. It's their right not to take their stand in their own defense. Kyle Rittenhouse takes the stand. I'm told it's a little more common in self-defense trials. He takes the stand. Who did it benefit? Did it benefit his side or the prosecution side?
It was a good idea for Kyle Rittenhouse to take the stand, and I think it was a strategic move by the defense, and I think it helped the defense. The jury was able to see Kyle Rittenhouse in his own words, describing what happened that night, describing what was in his mind as the events unfolded. And I think he made it very clear he was afraid for his life. He was running. Rosenbaum was chasing him. He was cornered. And based on his testimony, he was afraid that he was going to get killed that evening, which is why he took out his gun. Now, obviously, on cross-examination, I think the prosecution was able to establish to a certain extent, did you really need an AR-15? Weren't you intending to kill that evening? So it's going to be up to the jury to decide whether or not this was intentional or was it reckless. And I think the prosecution needs to be careful to make sure at the end of the day, the jury comes away with one or two of those issues, making sure he doesn't lose the jury as far as the reckless endangerment charge is concerned.
Terry, I want to follow up on something you just said. When a defendant takes the stand, each side has really one shot at the defendant, and any word, specific words the defendant say, can work against him or for him. Rittenhouse was asked whether he intended, as you said, to kill those people when he pulled the trigger. Rittenhouse responded that he intended to stop those people who were attacking him. So that kind of works in his defense. Did the state land any punches there yesterday?
No, and I think that Kyle Rittenhouse was very well prepped. That question was pivotal, and Binger asked it in the very beginning of the cross-examination. And Kyle Rittenhouse was very careful to say, no, I didn't intend to kill anyone. In fact, what I was doing was defending myself. He was making sure that he himself wasn't getting killed. Very well coached, and he answered the question sincerely. So I think that that worked in favor of the defense, and I think it backfired a little bit as far as the prosecution was concerned. I'm not sure the prosecution thought that Rittenhouse was going to be ready for that question. And in fact, he was extremely ready and did a perfect response.
There were sort of dueling storylines out of that courtroom yesterday. Of course, Rittenhouse taking the stand would have been big enough, but the prosecutor in the case got scolded, admonished, whatever you want to call it, tongue-lashed by the judge in the case twice. Thomas Binger, first for bringing up evidence the judge had banned, and then for appearing to question Rittenhouse's silence in the wake of the incident leading to the defense call for a mistrial. I mean, you're going up to the Fifth Amendment, and the judge even said to him as he was kind of raising his voice at the prosecutor, he said, look, you come right up to the line. You maybe have gone over the line. So why is this so important?
Both of those issues were very important to the judge. The judge did raise his voice. Frankly, in all my trial experience, I've not seen a judge yell at a party to the extent that this judge yelled at him. And so he was very upset. The issue on the right to remain silent was something that really inflamed the judge. He basically said, a defendant has the right to remain silent. You should not be touching that area. And Binger was trying to explain that the only reason he talked about it was because he wanted to know whether or not Rittenhouse was listening to all of the testimony in the courtroom. But that's an area he probably shouldn't get into either, because the defendant has the right to listen to the testimony in the courtroom. So the judge was very angry about that. And the other incident that you referenced, the judge had given a ruling, but Prosecutor Binger said, listen, I thought you left the door open, Judge. I thought you said that you didn't want us to include it, but if there were other evidence in the trial that opened the door, then we could talk about this incident that occurred at the CVS where Rittenhouse apparently stated, "I wish I had a gun to shoot these shoplifters." So the judge thought that Binger should have at least brought that subject up to clarify with the judge as to whether or not they could talk about that issue. So those are the two reasons the judge was very upset with Binger. And to your point, Phil, the defense made a motion for a mistrial, and Alex pointed this out, with prejudice, meaning it's all over. If that motion is granted, the prosecution cannot bring another charge in connection with this incident against Rittenhouse. So it's a very important motion. The judge reserved his decision. I doubt he's going to rule in favor of the defense, but he's upset enough that we might just well see that.
Yeah, it's good he didn't have to rule on that yesterday, as he was as upset as he was. Terry Austin, thanks so much. Beginning of a great conversation. We know you will be with us throughout the morning as we continue to cover this trial.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.